time when
Sorry.
he was born at a time when some neighbors would cross the street when we went outside because I think they thought it was contagious or something back in the early 80s. But bottom line is he's doing really quite well right now. He lives in a small group home run by Clearbrook, a board I've been serving on since 1989. And really, considering everything, doing quite well. More about him in a little while. There's a picture that you saw before if you were in Benji's session. I'll point out to you on the right there is when he was Benji's best man at his wedding a few years ago. Again, he's really doing quite well. So this session is about this situation. We have a loved one who is turning 18, and everybody in the world everybody in the country who's turned 18 is presumed to be fully legally competent until some judge, as I tongue-in-cheek say, some ex-precinct captain, now judge, determines that the person is not competent. So everybody is deemed competent, no matter if they have a IQ of 1, they're deemed competent until a judge says otherwise. So what happens when they turn 18? Well, the hand goes up and school says, well, we really can't talk to you without their permission. Doctors, hospitals say, well, we need their permission. What authority do you have? You have an insurance claim. You got to pretend you're them on the phone because they won't answer your questions or talk to you. If they're able to put their name on documents, technically it's a binding contract. Dealing with Social Security, as Sherry talked about, dealing with the state, HFS, the Medicaid agency, again, you have no authority whatsoever. Dealing with group homes, residential placement, ICFDDs, employers, government agencies again. You have a daughter who says she's getting married, and you say, well, wait a second. She really doesn't understand what she's getting herself into or whatever. The child wants to drive and you don't think they should be driving. Or the big one for me is you're dealing with the state's attorney or the police, God forbid, for your child who's either has a mental illness, developmental disability, or dual diagnosed. Bottom line is, as I say, it's not diplomatic immunity. What authority do you have to talk to the police or to be there or to get involved? The answer is really you don't have any authority. It stopped at 18. So the question is, all right, can this individual fully manage their own personal medical, education, and financial decisions? Even if they can, for a lot of these individuals, will they remain vulnerable or be taken advantage of? And if so, then the questions are always, before we talk about that word guardianship, we always talk about what are the alternatives. Before, it's like in school, he's talked about the least restrictive environment. Well, okay, before we jump to the end and talk about a plenary or full guardianship, what else can we do? So there are alternatives. That's the key thing to remember, okay? Option number one, always option number one, is do nothing, sit on your hands, okay? Actually, if you do nothing, you're doing something, because if the person does not have capacity, which I'll define in a second, for medical decisions, no capacity for medical decisions, purely medical, then Illinois has a statute called the Illinois Healthcare Surrogate Act. Again, if the doctor says that the individual doesn't have decisional capacity. So what is that gobbledygook decisional capacity? Well, I'm going to read to you, even though Sherry says I shouldn't read to you. I'm going to read to you this gobbledygook. The ability to because it's real specific. The ability to understand and appreciate the nature and consequences of a decision regarding medical treatment or the foregoing life-sustaining treatment, and the ability to reach and communicate an informed decision in the manner as determined by the attending physician. Bottom line is, the attending physician says that the individual does not have capacity to make their own medical decisions. If they say that, then there's the Illinois Healthcare Surrogate Act. If they lack decisional capacity and they didn't have the ability to sign a power of attorney for healthcare, obviously, there's no legal guardian appointed, then who makes decisions? There's a pecking order. Assuming they're not married, they don't have their own adult children, then either parent can make medical decisions. If there isn't a parent, then a sibling, including end-of-life decisions. But again, this is only for medical decisions, and the doctor has to say they don't have decisional capacity. Okay, so if we do nothing, we have something, so to speak. Okay, great. What's the second option? Well, next is, do they have decisional capacity? Supported decision-making, the new kid on the block, so to speak, okay? There were a few states that put this into law a number of years ago. Illinois always right in there is towards the end of the states, you know, it finally comes around and doing it. But supported decision-making basically says the person has to have testamentary capacity is defined in Illinois. And that is means, now not medical, now I'm talking about testamentary capacity in order for this option to be a viable option. To know and remember who are the natural objects of one's bounty. And what does that mean? Who do they have kids? They have grandkids? You know, okay, fine. So maybe that can be applicable to most of us, okay. Really, it's extended to mean, do they know who their parents are? Do they know who their siblings are? Okay, great. More importantly, to comprehend the kind and character of one's property. Do they know what they own, what assets they have? To make this, the ability to make disposition of the property according to some form of plan formed in one's mind. Can we mute, please? Thank you. So, again, seems like a little gobbledygook, but basically, this is what the law says, is that the person not really have the ability to make their own decisions and understand what they're doing. They don't have to have a genius IQ. They don't even have to have you know, Sherry talks about, you know, 70, 75 IQ. They don't even have, they could have a 50 IQ. So they understand who their family members are, what property they have, and what they would want to happen to some of their property. Okay, fine. So if we get past that, and again, it's very subjective, okay? In Illinois, as I said, always was right in there, February 27th, 2022, this year, finally passed this, okay? And they said, okay, we have this thing called supported decision-making. The statute, this law in Illinois authorizes it. And it allows somebody called a supporter, for most of us, it would be parents right now, maybe down their own siblings or whatever, to assist a principal, that's the person with special needs, with intellectual or developmental disability. Note, it doesn't say mental illness or anything else. The statute specifically talks about IDD, who has decisional capacity. That's what I just tried to define, or at least give you the blurb that they're saying is really what the definition is. They have decisional capacity in accessing, collecting, and obtaining information that is relevant to a decision authorized under the supported decision-making agreement. It gives a form that we'll talk about. So basically, they're saying the person has a decisional capacity, then they can appoint somebody called a supporter, not to make decisions for them. This is not a guardianship. This is not powers of attorney. Just the ability to get information for them. So in theory, that they can then assist the person with special needs, the principal, in making their own decisions. The principal may revoke at any time. The person with special needs can say, I changed my mind. Don't have to tear it up. They could tell somebody, don't listen to them, I changed my mind. Okay. Cannot make decisions. Again, under supported decision-making, the supporter does not make decisions, only can advise the principal, the person with special needs. If they don't have decisional capacity, as I defined, then guardianship is what is needed. We're going to talk about powers of attorney, but they have to have decisional capacity for powers of attorney. So if they don't have decisional capacity, we got the Healthcare Surrogate Act for medical decisions, but you know, that it's a pecking order of who makes decisions, and maybe it's an absentee parent that's making decisions. That's not what we want, but the statute has a pecking order as a backup. So you say, okay, if they don't have decisional capacity, guardianship, some form of guardianship that we'll talk about is needed. Okay, well, I want more information about supported decision-making. Well, one of my hats I've worn over the years for 6-7 years, I was on the Guardianship and the Advocacy Commission, which oversees public guardian's office on their website, which is on the screen and was uploaded for your information. There's the link there you can follow, and it gives you the state forms, the suggested forms, and the history of supported decision making. Some real good information on the Guardianship and Advocacy Commission website. Or you check number 5 on the information form that also was uploaded to you guys, and you'll be getting information that I'm going to talk about today, this whole section about guardianships, powers of attorney, and supported decision making. We'll be sending you information. So option number 3 is, okay, if we do have decisional capacity, then the Healthcare Surrogate Act won't work. Okay, fine. I don't need guardianship necessarily, but supported decision making, people can't make decisions for me. They just can talk to me but I have to make the decision. What's the other option that more often than not people are going to use? And that is powers of attorney. Again, if they have that decisional capacity. Now, when we do it, a typical person does it, for lack of a better expression, they normally do springing powers of attorney. I'm signing a power of attorney in case my doctor says that I'm not competent, then this person can sign my name, pay bills, make decisions for me. It's called a springing power. But for the individual with special needs, very often, we do an immediate power. As soon as they put their name on it, goes into effect, mom, dad, whoever can make decisions, subject to them, again, avoiding it. So Illinois has a form that started September 1987. They haven't changed it since September 1987 for financial matters. It says power of attorney for property, but really it's for financial matters. Because it's 1987 form, don't use it. You use it, but you have to add on an exhibit A, so to speak. It brings it up to 2022. So before I go on, what if they can't sign their name? Well, they print their name. Well, it's going to take up a whole page to print their name. They can make a mark. They can use a stamp. It's witnessed and notarized. So as long as the witnesses and notary agree that this person has decisional capacity to sign a power of attorney, doesn't matter that it's not a beautiful script signature. Again, I have to bring it up to 2022, not 2021 anymore. It's an old slide. IRS. The power of attorney from 1987 doesn't allow you to handle any IRS matters. It's got to be added in. Residential matters, employment matters, talking to employers, funding payback trusts, funding special needs trusts or ABLE accounts needs to be in there. A HIPAA release needs to be added in there. Getting user IDs and passwords, nobody thought about 1987, user IDs and passwords. Got to add that in, okay? And a big one, in my opinion, is copies. Okay, so I'm using a power of attorney, and that bank insists on an original, and this one wants an original. You don't sign 18 of these. No, we put in there that copies are just as valid so long as the agent is in possession of the original, so we don't run out. Among other things that have to be added in. So the power of attorney form that you can get online, it's a statutory form. It's a 1987 form, and we need to bring it up to date. Do we do it immediate powers for everybody? No. Some individuals with special needs, we do a springing power like with their parents, only as a backup. We also do these for their typical children that are going off to college, saying, well, they're off to college. All right, I'll have them sign powers of attorney so I can take care of some matters for them here without having to get them on the phone and take care of things. So then you say, oh, what about medical? Well, the Healthcare Power of Attorney Law in 1987 also did a one-page legal-size medical power of attorney form that was scrapped in 2011. They scrapped it again in 2015. They've tweaked it a couple times since then. Now it's 6 pages, and when you sign by Zoom, which we're allowed to do now, even post-COVID, it ends up being 7 pages. But basically, it's a much better form. Basically, it says who can make medical decisions for me if I can't make my own, including end-of-life decisions. And it builds in a HIPAA release so that even though your agent may not be making decisions for you now, the doctors and hospitals can speak with them so they're ready to go and they're up to speed if they have to make decisions. So it's a much better form. So if people have powers of attorney for healthcare, it predates 2011, they ought to talk to their attorney about updating it. Special education. Another power of attorney form. Sherry talked about that even if you got a good power of attorney, Social Security doesn't like it, state of Illinois doesn't like it, everybody has their own forms. Well, in 2007, what happened was a lot of special ed co-ops and special ed schools were not accepting the standard power of attorney, even if you added in special education matters. So the legislature passed a law in 2007, creating a specific special education power of attorney form. The difference is the other powers of attorney we're going to talk about, you do it once, if it's not voided, it's good forever. This one has to be done annually. So schools usually stick it in their annual meeting package, but it's got to be done annually. Okay, so that's that one. Well, what if there's also mental health issues, dual diagnosed? A lot of our clients are dual diagnosed, as my son is. Illinois has a 5-page mental health treatment form, which is even stronger than a guardianship that we're going to talk about, because a guardianship, you can't involuntarily admit somebody in a psych hospital. But if they sign a mental health treatment power of attorney form, you can for up to 17 days. It's a very, very strong form. I would tell you in 4 decades of doing this, I rarely do I have somebody with mental illness that signs one of these things, but it's there. Sherry mentioned already, Social Security has their own form, state of Illinois has their own form. Okay, so what if our child or the person we're talking about has capacity, but they say, I'm not signing that. I don't agree to that. We've had powers of attorney drafted for clients that the parents said, yeah, they're going to sign it. We get to the day of the meeting to sign it and they refuse to sign, even after we explain it to them and walk through it. Okay, fine. What if they don't have capacity to sign? Okay. What if they have capacity, but even with this, they can't help getting themselves into trouble, legal, criminal, financial, personal, maybe medical health. They have the ability to sign powers of attorney, but is it enough? Because they keep getting themselves, they keep signing things, they keep being taken advantage of. What if it's not enough to protect them from themselves or other people? So what if they have capacity and won't sign it? Or the first time you try and use it, they terminate it. Wow. What did my mom say? No, I changed my mind. Don't listen to her. Doesn't prohibit them from acting on their own. So, okay, I gave you a power of attorney that you could do things for me, but doesn't stop me from doing it myself. So I just did this, I just did that, I just signed to this. I just signed the paper at school. I'm not going for a transition. I'm leaving at 18. I'm leaving it. Well, it doesn't stop them from doing their own thing. It allows you to do things for them, but doesn't stop them, doesn't cut off their rights to do it for themselves. Will they remain vulnerable? That's really what I'm saying. So that is, will powers of attorney be enough? What if the young man or woman is on the computer buying things with mom's credit card? I've had similar type stories like that over the years from clients. What if there's an IEP 3 weeks ago you never heard about and you found out, and they said, well, we asked your daughter or your son, and they said, no, they didn't want you there. They overrode the power of attorney. They signed things, again, maybe ending their transition period. So they can't sign or they won't sign, or you just simply determine that a supported decision-making powers of attorney or healthcare surrogate act are simply not enough to assist and or protect them from themselves and from other people. Then maybe, just maybe, some form, because there's different forms of guardianship, some form of guardianship might be appropriate, again, to help them and to protect them from themselves and other people. All right, so we say, what is guardianship? Well, it's going to court. All right, we got to go to court. Well, for most counties right now, it's still by Zoom. I'm not sure how long that's going to last still, but okay. Got to go to court because you're taking away rights from somebody who's presumed to be legally competent. Again, until a judge says otherwise. So it's always that balancing act between independence and protection. We want our child to have as much independence as possible, be all they can be, so to speak, okay? But we also want to protect them, again, from themselves and from other people. So that's why we say Consider supportive decision-making, consider powers of attorney. But if it's not going to work, or we tried it and it's not working, and they got themselves into trouble, then we got to go to court. Again, it's a lawsuit. You're taking away rights from somebody who's presumed to be competent. So where do you go to court? The venue, quote unquote, the county in which the child has his primary residence. Could be a little confusing if parents are divorced and they're in different counties, but okay. You're going in the county where the child has his primary residence. All right, so we're going to file a petition. Okay, what else? Well, we need a doctor's report, an MD report. If the child is IDD, intellectual developmental disability, it could be a clinical psychologist licensed under the Clinical Psychologist Licensing Act. That's a relatively new change. But if they're not diagnosed as IDD, MI, anything else, physical, whatever, it's got to be an Illinois MD that signs the report. Every county has their own form. Usually it's one page. It's filed with the petition that the person needs a guardian. Okay. They have to be served with a summons because it's a lawsuit. You're taking away rights from somebody who's presumed to be competent. Got to be served with a summons. Now, this used to be that it had to be by the sheriff or special process server. Again, they changed that law recently that it can be any adult unrelated, not being named as guardian and, whatever. So it could be a teacher, it could be a medical professional or whatever, but they got to be served with summons, person that you're deeming to be incompetent. Who can be appointed? They don't have to be in Illinois. It could be a sister or brother that's out of state, as long as they're a U.S. resident. They don't have to be a citizen. They have to be a U.S. resident. They can be appointed. So some people say, well, in my will, which we're going to talk about, I want to nominate somebody as guardian, but they're not in Illinois. It doesn't matter if they're in the U.S. No, they're in Canada or Mexico. No, it won't be appointed. They have to be a U.S. resident. We also have to give required notices to who? The people that have equal or closer blood relationship. So again, what does that mean? Well, mom, dad, any adult siblings. What if there's a divorce? I don't care. You're petitioning, you got to give to the ex-spouse, the other parent, notice. Well, we're estranged from one of the adult siblings. They have to get notice. Okay. Now, if they have notice, they can hire an attorney, they can come into court. It doesn't mean that they're going to upset the apple cart, but they have the ability to speak, and the judge to hear their complaint or argument that you shouldn't be guardian, that somebody else should be guardian or whatever. Some situations are contested by the person with special needs. I don't need a guardian. What happens then? We'll talk about that in a second. Well, basically, the judge can appoint a guardian ad litem. We'll talk about that in a second, but they also can appoint for them effectively a public defender, an attorney to represent them. And all of a sudden, it's like being in litigation with your kid. Again, here's who can be a guardian. Got to be at least 18, a resident of the U.S. What if, especially when mental illness is a major player, and we talk about we don't want a sibling to be in the firing line. We don't want a sibling to be guardian, but there needs to be a guardian. We're concerned about liability and everything else. There's options. A couple options. One, the public guardian's office. If nobody will be guardian and the person needs a guardian, usually they only do it if the police is saying the guardian is necessary. The public guardian is a state public guardian and a county public guardian. If the person doesn't have any money, basically, it's a state public guardian. That, again, I was on the oversight board of Guardianship Training Commission. But generally, what we recommend is a not-for-profit, such as Day One Pact. And I think Nancy Fritz, I see her name is on here. Day One Pact has been doing it since the early 80s, operating as guardians, an Illinois not-for-profit social service agency for these situations, and it does an excellent job. Full disclosure, I was on their board of directors for 6-7 years, but I still say that they do an excellent job. So that's an option. Okay, so now talk about guardian ad litem. So you file a petition, and the law says that the judge can appoint somebody called a guardian ad litem to make sure that this person really needs a guardian. And if they do, that you're the right people to be guardian. It depends on the county. In the Collar counties, historically, it was McHenry County is the one that always would do it no matter what. But generally, in most counties, at least in the Collar counties, other than McHenry, if you put on the petition that the person will be in the court and nobody's objecting to it, they normally will waive it if nobody's contesting. The reason is that in some counties, that person has the ability to send you a bill besides your own attorney bill. They send you a bill. Again, most of the Collar counties, at least, depends on the county, but will waive this if it's an uncontested situation. Parents is call. I've seen people say, I did it on my own, and the form said one at a time, or that I was told I only do. No, you could be co-guardians. Okay, for co-guardians, we both got to sign everything. I'll give you the legal answer and the practical answer. The legal answer is each co-guardian can act independently. You don't need both signatures. Having said that, I'll tell you, in the real world, it doesn't work that way. Because schools, agencies, don't want to get caught in the middle. They want both signatures. There's a way around that, which I'm going to show you in a couple minutes here. But technically, my wife and I are co-guardians for my son, and that's what I always recommend. What if the parents are divorced? If the judge is convinced that you guys are on the same page about the kid, they'll make you co-guardians. It doesn't matter. Okay. Can they have a sibling and a parent? Yeah, it's up to the judge. Can you have 3 co-guardians? In theory, yeah. I've seen some counties that they'll do 3 and 4. Generally, in the Collar counties, they try and not do that. But in theory, you could. Again, if there's 2 siblings, 3 siblings, I've never had a problem with 2 siblings being co-guardians. I've had a couple pushbacks on 3 siblings. When can you do it? Well, again, I'll tell you what the law says, and I'll tell you what some counties do. The law basically says you can't file the petition. Some counties will let you file the petition for guardianship before the child's 18, but they can't be served with summons until they're 18. You can't have the hearing until they're 18. Most counties say you can't file the petition until they're 18. So that means there's always going to be a gap period. Okay. Person versus the estate. In most situations, the child has no money. It's very simple to guardian of the person. And then you don't have to, accountants, you just got to do a report. We'll talk about life's gonna be a lot easier. What about the Social Security? Most counties, especially all the Collar counties, they don't count the SSI or SSDI as a reason to become guardian of the estate. Guardian of the person is fine. There are some counties in Illinois further south of I-80 that do require for Social Security guardian of the estate, even though Social Security says they don't care. As Sherry said, they don't care about guardianship. They have their own system with representative payee. But again, we have some counties where the judges don't understand. Do I have to go back to court? I'm guardian of the person. I'm guardian of the person of my son. I'm gonna have to do a report, which we'll talk about in a second, but I don't have to go into court for it. Do I physically have to petition or go back to court for anything? Yeah. What? 1, residential placement. They're moving into group home. They're moving into an ICFDD or an SOTC, State Operated Development Center. Statute says that a guardian cannot move somebody into residential without a court order. Sterilization went in the law a few years ago. Tying tubes, vasectomy, cannot, even as a guardian. The doctor is not allowed to without a court order, sterilization. And what we have found, at least in the 6 counties that we work in, is that unless it's a medical emergency, the judges are not approving it. So if we don't have to go back to court because there's no money in the estate, it's just regarding our child for where he lives and medical decisions and stuff. What do we got to do? Annual reports? Well, maybe. State statute says that it's up to the judge. Most counties require reports, some annual, some every 2 or 3 years. Depends on the county. But now it's done online. Since 1/1/18, state statute says you don't mail them in, you don't walk them in, you do it online. Okay, there's 102 counties, 101 follow that. 1, Cook County, says, no, You do it online, but you also got to do it as a hard copy too. Even though the statute says you just got to do it electronically. Again, 1 out of the 102 counties follows the law. Cook County says, no, we're different. So we talked about residential placement. Here's what it says. It says that the guardian does not have the authority, unless specified by court order, to place the ward in a residential facility. Now, the next paragraph that's highlighted in there is something that sometimes we have to need to educate agencies on. The guardian shall monitor the placement of the ward on an ongoing basis to ensure its continued appropriateness, and shall pursue appropriate alternatives as needed. When the agency says, oh, you can only come visit on 48-hour notice on Sunday at 2 or 4 o'clock, you go back to court. Judge, I cannot do my job as guardian, monitoring the placement of the ward with the limitations that the agency is putting on us. Reasonable limitations because of the privacy of other individuals, okay. Can you please, there, thank you. But bottom line is technically we're supposed to have access. Okay, so we're guardian for our son, but now we're moving to Florida and our son's coming with us. Not so fast. Technically, if your son is moving with you, you're going to have to either transfer the guardianship or start a new guardianship, depending. Illinois has an agreement, like a contract, I don't know what the right word would be used. They have an arrangement. It was probably maybe now about 35 states. It's a transfer guardianship. You got to go into court there, you got to go into court here, but it's just a transfer. There's a handful of states. We still have to go close it here and open up a new guardianship in the state. So, all right, she's not moving out of state, but you know what? Mom and dad passed away. And now the sibling whose guardian just got a job in California is, I'm moving my brother to California. Again, you got to move guardianship. What if it's powers of attorney? Well, they're perfectly valid in California, your Illinois powers of attorney, but from a path of least resistance, you're going to want to get that California powers of attorney. So when they walk into the bank or the hospital or whatever, they're not going to look at you sideways. They recognize the forms. That's why if somebody is moving out of state, we always recommend, Benji's on the board of Specialties Alliance. I'm a past president. We have attorneys in 48 states. We do a handoff so that the family can get the proper documentation and review everything in the new state. Okay, so they're not moving out of state, but they're in DuPage County and now they just moved into Kane County or whatever. What do we got to do? Well, on your report that you're filing, you put the new address. Certain counties, in particular DuPage, very often McHenry, we've seen it, well, DuPage for sure will tell you, we want you to move the guardianship to the new county. More often than not, they're going to request it, not require it. But again, the state statute says you're still in Illinois, you don't have to do anything. So you just put it on the report to new address. And unless the judge says otherwise, you don't have to worry about it. So if some parents or siblings decline to act because of potential liability, what do you do? Well, one possibility is a limited guardianship. I'm going to talk about that next. Or we'd say, let's talk about using somebody like Day One Pact as guardian, and let's step aside. State guardian or private like Day One Pact. Okay, so you mentioned the Healthcare Surrogate Act about medical decisions. Yeah, the statute says if you're a guardian of the person, you're number one on the list to make all medical treatment, including end-of-life treatments, or to give permission, I should say. Here's another biggie, though. Driver's license. Some of our population are going to drive. They may have the ability to drive. Okay, great. They passed the test. They got it. Fine. Okay. If you did a full plenary guardianship, guess what? The statute says, It says, what person shall not be licensed as drivers or granted permits? The Secretary of State shall not issue, renew, or allow the retention of any driver's license, nor issue any permit under this code for anybody adjudged mental, physical. Bottom line is, full plenary guardianship, it's an invalid driver's license. However, DMV, by their own admission, doesn't follow the law. The state statute says that there's a plenary guardianship, the court has to notify the Secretary of State. Why? Because of this. DMV says, nah, if we get a medical doctor's letter saying that they have the ability to drive, we'll still give a driver's license. My answer to clients is don't do it. If there's an accident, the insurance company has an out. It's an invalid driver's license. Well, they were giving it to it. Well, they acted outside the law. The statute's very clear. It's an invalid driver's license. We don't want the guardians to be personally liable. Statute's clear. Secretary of State is misreading the law, which we've told them a number of times. Paragraph 8 in this handout here says that if the person doesn't have a guardian or it's a limited guardian, they can have a driver's license. But if a doctor says, if somebody says they shouldn't have a driver's license, it's rebuttable with a doctor's letter. But the top paragraph, paragraph 5, if it's a guardianship, plenary guardianship, it's not rebuttable. It's an invalid driver's license. This handout is available, the statute, I should say, number 8 on the information request form. So why will we do a limited guardianship? A limited guardianship is limited to whatever is on the court order. I'm taking away certain rights from this person. Okay, yeah, just A, B, C, D. Just medical decisions, just employment decisions. I'm listing 3 or 4 or 5 things. That's what a limited guardianship is. So when do we do it? They need a guardian, but they won't cooperate. So maybe we're going to try and say, well, I'll tell you what, let's just do a guardianship over these 1 or 2 or 3 things to get so they won't object and they'll cooperate. Or we're concerned about they're going to hurt somebody, they're going to break things, property damage. If I do a limited guardianship, I'm not responsible for all their actions, just for these 3 or 4 or 5 different areas. They're going to be driving again, limited guardianship. So limited is another reason. A limited guardianship by statute does not constitute a finding of legal incompetence. So why is that important? You ever see one of these employment applications? And one of the boxes is, have you ever been declared to be incompetent? Well, limited guardianship, you can legally and truthfully say, no, you haven't. It's not a declaration of incompetence. It just means you need help in these 1 or 2 or 3 areas. Okay, so September 8th, 2018, another Illinois law passed. Guardians have to be trained, even if you're the parent. There's online training for outlining the duties and responsibilities of a guardian, rights of the person with a disability. It's done online. It initially was applicable to 101 counties, not Cook County, because people in Cook County are smarter and they don't need to be trained, but the other 101 counties need to be trained. And I could say that because I live in Lake County. Okay. Bottom line is, they now decided that, yeah, maybe that wasn't right. So effective 1/1, this coming January 1st, this training will apply to all 102 counties. If you're already guardian, it doesn't apply to you. This is for new guardianships, okay? Now, it also can be waived. It can be waived for, well, you could see the tax correction, not for God cause, for good cause. Bottom line is that, we often will say to the judge, we've been the parents for 18 years now or whatever, we don't need to be trained. Bottom line, it's no big thing, but it could be waived. Office of State Guardianship, I showed you a link before from their website for this supported decision making. They have great information on guardianship and alternatives to guardianship. And then there's also the guardianship training link. You see towards the bottom there highlighted. You could do a practice one, even if you don't want to, just to see what it's like. It's not bad. You read 2 pages, you answer 3 questions. You read 3 pages, you answer 2 questions. You click off, you get a certificate, you passed, you send it into the court. You got a year to do it after you're appointed a guardian, and you're done. So co-guardians, again, law says either guardian can act independently. Yeah, you're gonna have a problem with agencies, doctors, hospitals, they want both signatures. I don't want to get caught in the middle between the parents. So what do? There is a short-term guardian declaration law. What is it? It's a statute that says, without going to court, guardians can delegate their guardian authority to somebody else for up to 60 days in a 12-month rolling period. Okay. So my wife and I are going out of town. We can give Benji the form. Okay, they get us on the cell phone. Well, but the hospital may or may not accept that. Okay, whatever. Somebody with feet on the ground will have authority to act in our behalf. But only 60 days in a 12-month period. Yeah, but nobody's really keeping track of that. And nobody's ever questioned it, but okay, fine. Short-term guardian. Can't exceed 60 days in a 12-month period. And you have the authority that the person had. So if they're limited guardian, you're delegating the limited guardian authority. If you need a guardian of the estate that I alluded to before, in addition to guardian of the person, we don't want one because then the judge is second guessing you're spending the money. You need a budget. They can second guess you on expenditures and everything else. Again, Social Security, Collar counties, we don't have to worry about it. But if you're going into court to file a petition, you got to put down what assets are in the child's name. Less than a few $100s, nobody's going to worry about it. But if it's more than minimal, the judge might insist on it. Social Security, as I said before, in most counties, they don't count Social Security. Lawsuit settlements, we need the guardianship. Incorrectly left inheritance by grandma, they left each of the grandkids money or whatever. Needed money in their name. 529, no, it's not their money. They're only a beneficiary. An able account by statute is not subject to a guardianship. Okay. You could, even if you're guardian, you could set up an able account outside the guardianship, again, by statute in Illinois. So if you're going to go in for guardianship, what I recommend, if there's money in the child's name is $10,000, $11,000, $12,000, we open up the able account beforehand, get it out, and have less trouble when we get in the court, no second guessing. If you're guardian of the estate, you have to put the surety bonds. You have to pay a premium for it, saying that you're not going to steal the kid's money. And you have to have accounting and reports, and the judge has to approve expenditures. So again, I would say 99% of the time, if there's no personal injury settlement, there's no significant dollars that were left to the child's name, we're doing guardian of the person only. We're not doing guardian of the estate. What about voting? Hey, people, this is Illinois. You could be dead and vote several times. It doesn't matter that you've been declared to be incompetent. They can't do any worse than we do, can they? Okay. So bottom line is, you know, I've lectured on this topic nationally for the ARC and for NAMI. In most states, you've been declared to be incompetent, you can't vote. I mean, you've been declared to be incompetent. Not in Illinois. Be a full plenary guardianship, you still have the right to vote. Guardians are nominated in the wills. Illinois, even if you say, I don't think I need a guardian, I want to be of record that if a guardian is necessary when we pass away, because people bend the rules for mom and dad, but not for sister and brother. We were never guardian, but now they're going to go become guardian. You have the ability to be of record. My cursor went to the wrong screen. Hold on a second here. There's a statute that says a parent, not a sibling, but a parent can designate in their will who would be successor guardian. So in the will, you can nominate who will be successor guardian. A lot of the boilerplate wills we see say, I'm nominating a guardian for my minor children. It's not good enough. We always want to say, and for this child, if a guardian of an adult disabled person is necessary, that this is who I nominate. So who's going to be guardians? So in your wills, you're going to nominate who's going to be guardians, make all medical decisions, government benefits. We do this for minor kids all the time, but now we're also doing it for a successor guardian for our child with special needs. So who do you pick? It's a job that's going to last them. It's not going to end at 18. This is a job that they'd have for their lifetime, and then somebody else will be taking over. Should it be siblings? Depending on the level of the child with special needs, you might say, I don't want to do a sibling. He has to go to his brother for about his money and everything else. grandparents maybe for a period of time. What school district do they live in? Because they're still in school when you pass away. That special ed program and that guardian's school district will be now the special ed program for their child. Things to think about. A married couple. Do you mean your sister in the church she married, or you mean your sister? If she passed away, do you want your brother, your former brother-in-law who's now remarried, to be the guardian? Think about, just don't put it down the sounds. Who should be guardian? A single person, a married person, whatever. For his minor child, there's also a short-term guardian form, different statute. But if you're going out of town, you have minor children, even if they're not special needs, you could delegate your parental authority to somebody else for that period of time. One more topic before I take questions, and that is, I think I'm supposed to be done at 4:30, right? 3:30, yeah. Letters of intent. I call it guidance for the future team. See, if all this information about don't let my kid be alone with Uncle Harry, history of doctors, we never want to see those guys again. Medications we tried, don't ever try it again. Just as important as who they see now and what medications are on now. Buzzwords, do's and don'ts. Thoughts about the future, where they should live. If somebody's passed away, should they go to a funeral or not go to a funeral? The last correspondence from the government for Social Security and Medicaid. Where are our estate plan documents? Did we make funeral arrangements? A lot of my clients, as we did, make funeral arrangements for a child with special needs, so it's done ahead of time, but they don't tell anybody about it. And so what do you do? An executive summary. You have all this information in a 30-page book, and you say, I'm going to send a PDF to the next named guardians and trustees. And they say, what are you sending this to me for? I said, just humor me. I know you got it if something bad happens. But then they're saying, God, something bad happens. I need to know what I need to know to get by the next 24 or 48 hours, called the executive summary. So on the request form, number 2 is a fillable PDF form. If you do number 2 on that form, we're going to send you a bunch of stuff. One is a form that you could use, letter of intent form. Again, I apologize, it's a 40-page form, but also 3 articles I've had published at different places. EP Magazine, Parenting Special Needs. Bottom line is they'll send you those articles too that give more detail what should be in a letter of intent and what should be in the executive summary. If you didn't see here Benji earlier when he did present it on special needs trust and able accounts, when you talk about letters of intent, siblings should be part of this planning and it's a discussion because they're going to be the care providers maybe for more years than we've been the care providers. Benji's president of SIVS, which is a state chapter of a national organization of adult siblings with special needs. The website for the state chapter of Illinois is on the top. On the bottom is the national organization if you have siblings that are out of state. We have the information form for siblings is number 7. That's the information form. We're going to take questions. Let me go back here for a second. Before COVID, during COVID, they allowed us to do signings of estate plan documents by virtual. And now by statute, we can do permanently, can do signings of documents. We do initial meetings by Zoom. So it doesn't matter where you are in the state, we can really serve you. But on the bottom here, specialneedsalliance.org is our national organization. If you go on their website, you can find an attorney. The Special Needs Alliance is a vetting process. You have to be recommended, approved that you're specialized in this area. And so it's a membership by invitation. If you can't find somebody in your county or close by, and you don't want to do it virtually, the other organizations, Academy of Special Needs Planners, I was a charter member, Benji's a member. You can find an attorney there. But don't go to a general practitioner. Don't go to even a general estate planner. Look on the Special Needs Alliance or the Academy of Special Needs Planners to find somebody that's competent. Special Needs Alliance, most of our members are fellow either parents or siblings. With that, I'm going to pause and ask for help and somebody doing questions because all of a sudden.
Yeah, Brian, we have one question here. We have 2. Here's the first one. This is from someone who couldn't be here today, but asked us to ask you. Parents are divorced. Mom has sole guardianship, but child now lives with dad in a different county. Dad wants to be co-guardian. Mom says okay, but might not be helpful in getting it done. What should dad do?
I'm not sure what about not being helpful in getting it done means. Dad needs a petition in the county where the guardianship is now, to be added on as a co-guardian.
Okay.
If mom signs the petition or agrees, it shouldn't be an issue. If depending on what county, but generally not going to be an issue. If she's not cooperative, but doesn't object, probably still wouldn't be an issue. May have guardian ad litem, but maybe not. If she does object, it gets to be like litigation, contested litigation. Depending on what county dad is in, the judge might insist on a transfer of the guardianship to the other county. Again, I don't know what counties mom and dad are in.
Yeah, we don't know either, but we'll share that information and let them know they can contact you if they need more details, correct?
Yes.
Okay. The next question, I think you answered this, but we'll double check. What line item should we check to get for the executive summary? So I think you said that was item number 2. Is that correct?
I believe so. Yes, number 2.
Number 2.
Number 2 will
Okay.
get you the form for letters of intent as well as the articles. So the form and the articles will be in there.
And it will also, as part of the letters of intent, it has the summary to save
Right.
the
right,
short version. Okay.
Right. And also number 1, I don't know if we mentioned it or Benji mentioned it before. Special Needs Alliance organization has a handbook on special needs trusts. This tab number, it's number 1 box. It's a PDF that we could send out too. We have it in English and we have it in Spanish. So if anybody wants, for washroom reading purposes, check it out.
Funny. Well, I think that one does it for now. Thank you so much, Brian. So much great information, and we also appreciate that we can complete this form and get even more detailed information because, it's like taking a course, right? We need to study it, read it, highlight, and then we'll get back to you with our questions, Professor Rubin.
Yeah. Take care.
All right, take care. Thank you so much.
Thanks, everyone. We're going to end this session and we'll pick up at 3:45 for our last one of the day. Thank you.
Awesome.